All right, it is 32 after. We're going to go ahead and start. I'm just going to kick it off with some quick announcements. I'm Megan Zern. For those who don't know me, I'm the president-elect of PLDF, and welcome to part 2 of our 3-part soft skills webinar series. This is the middle of the case, so it is entitled, I don't even know what's entitled. I think Hannah does, though. It's with an eye on the resolution, litigation, soft skills, middle of the case. Before we get started, Hannah Stone is going to moderate, and I'm going to kick it over to her. But before we get started, I just wanted to encourage everyone to register for the annual meeting. If you haven't done that yet, it's going to be in Las Vegas in September. So please go ahead and register for the annual meeting. Can't wait to see you all there. Also, for any of you who are not members yet of the PLDF, please consider joining and get more access to content like this and the committees, and we'd love to have you. And with that quick intro, I'm going to kick it over to Hannah.
Great. Thank you, Megan. Hi, everyone. My name is Hannah Stone. I'm an attorney at the Milo Drive, Dale and Steinbetter law firm located in beautiful Missoula, Montana. I will be moderating today, and we have an excellent panel. We'll start with Andrew Carroll. Andrew is a member of the Clark Hill PLC Philadelphia office, where his practice focuses on defending legal malpractice claims and real estate litigation. Next, we have Barbara Serafini. She is a senior vice president with Gallagher Bassett Specialty, where she handles complex caseload of professional liability claims against lawyers, insurance agents, title escrow agents, and other miscellaneous professionals for various insurers. And finally, we have Megan Zern. Megan is a claims manager for lawyers' professional liability claims at AXA XL and is also the president-elect of PLDF. She sits in Atlanta, and her AXA XL team of skilled claims professionals handles claims against lawyers and law firms nationwide. So thank you so much for being on our panel today. We are going to start. So the purpose of today's presentation is about the middle of the case, discovery and litigation, with an eye on resolution. So I'm going to go ahead and turn it over to the panel to discuss sort of the discovery scope and some tips and practice areas from the litigation perspective, Andrew, and then the claims side with Megan and Barbara.
Okay. So from outside counsel perspective, obviously, when you get a case in discovery, and discovery cost is one of the first things that you're looking at when you're figuring out what the case is about. And I think that you can learn a wealth of information from the complaint, both substantively and how it's presented to you about what the case is going to look like in discovery. First of all, just at the high level, how detailed is the complaint? Are we looking at a complaint that has 185 paragraphs? Because that says to me that plaintiff's counsel is very detailed and will be putting a lot of effort into the case, which means you're going to be getting more thorough discovery requests. They're not going to be afraid to file motions. You could just expect a bigger case as far as discovery, both in cost and in substance, than you otherwise would have. Also looking at the case, or the complaint, I'm looking at what type of entities or individuals are you representing? Is it multiple parties? Is it business entities? Is it individuals? Because that gives you an idea of how many witnesses you're going to be dealing with. If it's a corporation or something like that, you could have 5, 6, 7, 8, 10 people who have, touched on this issue at some point. And again, if you have a super detailed complaint, you need to be prepared for plaintiff's counsel to want to depose each and every one of those people. The last thing I really look for from the complaint is what's the timeline we're looking at. So if this is, a memo of understanding between two companies or a lawyer an engagement and it ends right away, they fire them, whatever happens, then you're looking at a limited time frame, which limits how many emails there could be. It limits how many people can be involved. It's just going to restrict the timeline of the case. Whereas if, the allegations start in 2016 and, the case ends, so to speak, in 2023, okay, well, that's a lot of time that's going to be encompassed here, which again, just increases the amount of people that are going to be involved, the amount of emails you're going to have to search, the amount of documents that are going to be involved, and just all of this goes into how complicated the discovery is going to be, and in turn, how expensive discovery is going to be.
Yeah, thanks, Andrew. And I think from the claims handler perspective, I mean, what we don't we're not looking at the minutia. We're not looking at how many witnesses, how long it's going to be. What we're looking at is big picture, and what we want to know is big picture, because what we're trying to do from a claims handler perspective is try to figure out how much is this going to cost to resolve this. What's our best resolution strategy? So that's why when this is like the middle of the case with an eye on discovery, it's like you're always thinking about how are we going to resolve this? What makes the most sense in this particular matter to try to resolve it, and how are we going to get that done? I think in the middle of the case, there can be sometimes a tendency to be like, well, we always file RFAs, request to produce, and interrogatories, and we just do the same ones every time. Or, we always do extremely thorough ones that we're going to send out 400 of these and inundate them. But what I want in my cases are, why are we doing that? Is this specific to this case? How does this further this? Not just like, oh, this is what we always do, and so we're doing it. This is how you litigate a case. You always do this in discovery. It's kind of like we want it tailored to fit what we're trying to achieve. And in order to do that, you need to figure out what is it that we try to achieve? What makes sense in this particular matter? Barbara, what do you think?
I'm here nodding, Megan, because I can't agree more. I feel, when we look at a complaint, we're absolutely looking at what do we need to do to get this to the finish line. And there's nothing more refreshing than having defense counsel call and say, I've talked to the insured, I've looked at the complaint, and I think that really we just need some targeted discovery to get us through summary judgment on this one discrete issue, or this is a case we really should be looking at to resolve, but I want to lock in plaintiff on her testimony on this issue. So for our purposes, it's really helpful if counsel can look at things with an eye towards that, so that we're not just getting the same rote discovery, that we're serving without really much thought to where that's taking us.
Right. And sometimes, it might be a matter in which liability is not good, is very challenging, like a missed statute where we have no defense on liability. And so then maybe some discovery on damages, but in some cases, damages are also not necessarily disputed. And so does it really make sense to go through the time and expense of discovery in those situations in which we don't really have much to gain from discovery? It's just kind of just churning our wheels and spending time and money, and for what?
Yeah, I think from the outside counsel perspective, this is all just a probabilities game from start to finish through appeal. We're just figuring out probabilities and the costs associated with it. So I think in a situation like Megan's describing, where okay, we have a statute of limitations defense, like could I turn over every stone to see if I can somehow wiggle my way out? I mean, maybe, and maybe there's a 1 in 5 million chance I'll find something that will somehow help. But, is it worth spending a whole bunch of money and time deposing every single person I can think of to find something that probably isn't there? No. How expensive, how much do you want to pay for that lottery ticket is really what some of these cases turn into. And so that's something I also try and keep in mind. Like if liability is a really tough case, okay, well, that's something we're going to live with and we'll see what we can find out. But, again, you don't want to just, churn your wheel trying to find something that's not going to be there or has a highly unlikelihood of being discovered at any point.
And I think in those scenarios too, it's really important to talk to the client, the insured for me, because sometimes the client may have very specific and strong feelings on how discovery should be should be handled, and what you should go after and how tenacious you should be. And those kind of feelings, or just positions and strategies, sometimes need to be discussed in the group, because it may not be something that you as outside defense counsel agree with, or that the carrier necessarily agrees with. So we take a very collaborative approach usually. So it's talking through with the client and the insured saying, well, we understand that you want to really zealously defend this and go after this. However, it seems like here are the challenges and here are the focus areas. And our plan is to try to hit those versus like the shock and awe approach that sometimes an insured or client may have. Hannah, have you had that kind of come up before where there's differing approaches?
And one thing that I think that I've started implementing in my practice is because as defense attorneys, we're already a step behind because we get served with a complaint. We have 21 days to catch up. And so one of the things that I've started doing in my practice is when I serve my answer, I also serve my initial discovery requests, typically very targeted. but also just to get especially documentation and sort of flesh out some of those facts. Like, for example, if, liability is against us, I'm going to want to get discovery out quickly on damages so that when I hit my 45-day or my 60-day reporting guideline, I can actually give a little bit more of, an analysis, as opposed to saying, well, I don't have this document or I haven't seen this information. By pushing discovery, and again, usually just a simple set, just to get basic information tailored. But if I can get that information back within the first 45 days, um, from a practical standpoint, it gets me more information so that I'm able to share that with my client and my carrier. But it also puts pressure back on the plaintiff. It makes the plaintiff start working, which in my experience, they're not expecting discovery for 3 to 6 months. And so when they get it with my answer, they're always going to ask for an extension, which I'm going to gladly give them. But it kind of puts, it puts us back in the driver's seat. And then it gives me breathing room as well, because then they're not going to be as quick to maybe send us discovery or, get us moving because they're working on their discovery. So that's kind of a practical point that I've implemented. That's worked pretty well so far.
Nice.
Then actually this leads us right into litigation guidelines of the carrier. Number one rule, know them, right? Let's talk about from the carrier perspective on discovery. What are some challenges and sort of trends that you've seen in managing discovery working with your litigation counsel?
So from
Sure,
my
so-
perspective, oh, sorry.
Go ahead, Barbara, please.
Thanks. From my perspective, I'm working with a number of different carriers, and I can say that they're not all consistent in what they want. So I'm going to hammer away again that it's really important to read those guidelines and to understand when your periodic check-ins are supposed to be, what you have to ask for permission to do so that you're not billing for it and getting it rejected and then having to go back with the, your tail between your legs and ask for permission retroactively. So all of those things are really important from the outset. As far as any trends that I would say that, in working with at this point 9 carriers currently, they don't want to approve everything right off the bat. So I think there's usually phase level approvals that they're looking for. They want information at 60 days, 90 days, 120 days about where you see the case going before you just willy-nilly send out, deposition requests, subpoenas, et cetera. So, and especially there's a lot of scrutiny on when it's permissible to hire an expert, what's involved with that as far as, retainer fees, et cetera. So again, it's just really important to open those lines of communication with your carrier clients to make sure that you're on the same page.
Yeah, I would agree with all of that. I mean, they all are different in the guidelines. And so you need to know what the guidelines are, what the rules are. And then just to be clear, the e-billing is the bane of all of our existence. We hate e-billing. Everyone hates e-billing. It's very annoying to everyone, the administrative headaches that everyone goes through, and they're all kind of different and they have different TPAs reviewing the bills or even manual review. It's all bad. It's all annoying, especially in November and December when we're all doing this. But the best thing you can do, I think, from a counsel perspective to help yourself is to know the guidelines and to be in good communication with the claims handler and to kind of know their preferences or check in on their preferences. I think right now, we're all, again, our goal from a claims perspective is to try to figure out what's our best strategy here and how much is it going to cost to execute that strategy. And so that's what we're kind of constantly checking in on is, is this fitting in with what our strategy is and the plan? And I think that it helps, we have all our budgeting in e-billing, which are part of the guidelines, but those budgets can be really difficult to understand and read. Sometimes they're in like a system. Different companies have different ways in which it's shown to the claims handler. It might be like life of matter, it might be phase, and they're kind of ballpark. So sometimes it's helpful to check in to say like, we're looking at this targeted discovery to file a motion for summary judgment. We think this portion will likely cost 35,000. However, if this, if it changes, we need to know that. And when experts are involved, we need to kind of know what the expert costs are. So checking in, our company, it requires handler approval before any experts are retained. And what I'm looking for there is to know, is this expert's rate commercially reasonable? And a copy of their CV kind of to see, is this the appropriate expert for this matter, which you as the attorney should have already vetted and made sure. Every once in a while I get a CV and I'm like, well, this person looks like they're only a real estate attorney, and our case is about a trust and estate matter. Why do we have this expert? It doesn't seem like they're the appropriate expert. So every once in a while, we do ask kind of some clarification questions on that piece too. But typically, if you have done your homework, and also if you've done good work for us before and we have that level of trust, so it may be something where the first several files you handle for a particular company, for a particular handler, they may be slower and there may be more questions asked and more back and forth. But then if you do a good job on those and things go smoothly and you've shown that level of excellence in your attorney work, then there can be a level of trust that there may be less questions in the future assignments. So that's, I think, at that kind of beginning phase in the litigation guidelines, how we typically find they go.
Yeah.
Andrew, do you love guidelines?
I mean, there's always some little quirks between them too, but frankly, a lot of them, it's all really common sense stuff. Like you said, with the phased approach to things, I think just from a practical perspective, I like it too. Like, why would I want to both get your document responses, your interrogatory responses, and have depositions scheduled all within 60 days? That doesn't make sense to me, just from a analytical perspective and from a cost perspective, because that's how you miss things. And then same thing with the experts. We hear a lot at presentations, experts early, experts early. I would tell you that in under 10% of cases, probably less than 5, do I actually feel the need to have an expert that early. The only caveat that I would have is that make sure that, obviously, your local rules, because depending on how, different states operate discovery differently. So for example, like in Illinois, they'll have tight deadlines for written discovery, for depositions and stuff like that. Whereas in Philadelphia, for example, it's kind of a free for all until the end of discovery, and then it's time for expert reports. So, if you have a really complex case in a substantive area of law, like I'm talking legal malpractice case where you're not as familiar with it, you need to be aware that maybe you want a consulting expert to just make sure you get whatever documents that they will need, because once the deadline passes, the deadline passes. And, again, it's a state by state. In Philly, we don't worry about that. We can wait till the end. But I always try to keep that in mind, depending on what jurisdiction I'm in.
Yeah, and sometimes what we do, or what our defense counsel does, is sometimes they retain an expert, but don't necessarily have them start working yet. They have them clear conflicts and maybe get them some initial documents, but so that they can like have a very initial view, so that they know that the expert's not going to be adverse to us. Because every once in a while you do reach out to an expert and they're like, I can't support that opinion. But that they have kind of a thumbnail sketch, but don't really dig in yet, so that we have any disclosures that need to be made by any deadlines, that we can make those disclosures, but don't necessarily incur the cost, because our resolution strategy may be to file a motion for summary judgment and try to mediate with that as leverage. And that we hopefully don't anticipate that it's going to need the expert or go that far. So that's one kind of strategy that sometimes our defense counsel employs to help us from a cost savings perspective, but also make sure that we're prepared if we do need to go forward and try the case. Another kind of, I have a question, I guess, for Hannah, Barbara, and Andrew on with depositions, virtual depositions. I know that's especially since COVID, there've been a ton more of Zoom depositions, it seems, and not nearly as many in-person depositions, especially when it's like out of state parties or witnesses. Have you been utilizing those, or how have you found those? And anyone, I guess, can jump in the chat too. If anyone has strong feelings on this, feel free.
I know. So, I mean, I live in a big state, but small, small jurisdiction. Especially if it's a key party, if it's your plaintiff, If it's someone who you really want to see how they are going to appear before a jury, I do in-person depositions. I think virtual depositions are great, especially, frankly, for experts, because they're never going to be in Montana. You're going to be traveling no matter what, and so it's much easier to work through a deposition with those folks, not having to incur 6 or 8 hours of travel time. But I do think that there are certain key parties where you need to be, I recommend being present. And then, of course, when your own client is being deposed. I have, other than COVID, I have always sat next to my clients when they're being deposed. I think it's incredibly important. And so even if my client has moved out of state or is, 5 hours away, I certainly don't want them being in the same room with opposing counsel without me there. But also even I've sat next to them on a Zoom call or a Zoom deposition as well. But those are all discussions that we have early on in making plans for these depositions, which ones we're going to travel for, which ones are in person. But yeah, it's been my experience that I still prefer an in-person deposition for those key players. But Andrew, Barbara, pipe in.
Yeah, I do it case by case. I don't mind Zoom depositions at all. Like you though, it obviously depends on how badly do I think I need to see this person, in person. So, for example, if I have a case that's going to be really sensitive and there's going to be a potentially really sympathetic facts or a potentially really sympathetic witness, I got to see that person live because I want to know how the jury's going to see it. Like you, Hannah, I also do like to be in the room with my client when they're being deposed, but like a document intensive case where, I'm not really that thinking, I'm not really that worried one way or the other about the witness appearing. Like technically I've never been one to need an associate to hand me exhibits. Like I do it myself and I find it to be very, very efficient to do it by Zoom. But again, it's really a case by case basis. And I talk to that with my clients, with the carrier. And frankly, also it depends on where it's at. If it's a Philadelphia case with Philadelphia witnesses, just do it in person. I'm not losing any time. It's when, you got to go to California or, Montana or whatever, then it's okay. But frankly, if there's a multi-state thing going on, a lot of times it is going to be worth it because there wouldn't be this many attorneys involved from this many states unless there was a lot at stake. So again, case by case basis though.
I would agree with that 100%. I would say, there is almost an expectation from the carrier side post-COVID that everything is going to be done remotely unless there are circumstances that warrant it being in person, because we've gotten so used to the cost savings associated with doing everything over Zoom. So I would recommend having those discussions with your carrier reps early on. If you feel that there's a reason why they should be in person, everyone is open to that, of course, if it's what's best for the case. But I would say that the majority of carriers are now operating in this post-COVID litigation world where it's easy to do these depositions remotely. And obviously, carriers are always in favor of saving whatever fees and costs they can.
Yeah, and I think that probably some carriers' guidelines will dictate some of that too, and the free approvals for any travel, et cetera. So check in on those as well. And I know with ours too, I know Barbara had mentioned retention or retainers for experts, and that's something that our company doesn't do. The response that I got from our old head of was, we're a however many $billion entity, we're good for it, basically, which I know can be challenging. Some experts do require those retainers, but that could be something to discuss ahead of time as well. Also, from just a tip on the cost savings that Barbara mentioned, when you are talking about depositions, if it's videoed, court reporter, many of the carriers do have business relationships with certain court reporting companies or videographers. But I would say I always recommend people to ask their assistant or paralegal or whoever they normally do it. Usually they check in with 3 different companies, get quotes, and see what is the most cost effective here, because I think those can sometimes vary widely as well. So it's just, and we appreciate it when you all are being efficient on our behalf and making sure you go through that diligence before retaining those outside vendors.
just a practice point on that. I had a carrier who had a preferred court reporter, entity group. And so they had said, hey, we want you to use, go through this court reporter service. And the court reporter was literally 600 miles from where the depositions would be taking place. And so I did call the carrier and I said, this is a wonderful court reporter. I have worked with her before, but she's 600 miles away. So we are going to have to build, just be aware of that. And my adjuster was actually very grateful for that because they're just, they were just like, we always use, this court reporting service, go through, use that. And, we had someone 15 minutes away that we could use, so I just brought that to their attention and I found them to be very open to that, but I've also had the situation where they say nope, just go with the person that we have. Special virtual virtual court reporters, I can pretty much appear from anywhere, but for in person, just kind of knowing those sorts of things if you live in a large state.
And I saw we had no comments on the chat, so I'm assuming everyone loves virtual and depositions and has no problem with them at all, or agrees with everything that Andrew and Hannah said.
Well, let's go ahead and maybe move on to updates. We're talking a little bit about know your carrier guidelines. Let's talk about those things like significant developments, costs, if you foresee privilege issues, or if there's a sudden a key issue changes in your case. What, Andrew, do you have a tack that you take for these significant developments? Do you file guidelines? Let's talk about how you work with your carriers.
Yeah, I mean, obviously, first things first is what did the guidelines tell you? Some will have more specific deadlines. There's everybody's got the first deadline, but after that, it really varies. So that should always be your starting point is what are the requirements, and then I'll just calendar it as soon as the case comes in. I'll calendar those deadlines out. Outside of that, a couple of different things that I look at. First of all, like what is the phase? We talked about the different phase discovery. So, if I get a whole 50,000, 100,000 documents in, like I know that the client's going to see a bill for reviewing 50,000 documents. So a good rule of thumb is like, how big is your bill going to be at the end of the month? And have you checked in and let them know that A, that's coming, and B, what's going to come out of it? Because, if I'm the client, for example, I wouldn't want to get a bill for $50,000 one month and have heard nothing since the last invoice. That would annoy me. So even if I'm not done with the document review or whatever, something like that, that A, should have been preluded with a conversation, and B, there should be a follow-up prior to that invoice going out saying, hey, here's where we're at. It's taking a while. Here's how we can make it go quicker. We can't make it go quicker. Something like that. Depositions, of course, you always do. I mean, I never do deposition summaries in the traditional sense of the word. Obviously, the carrier should already know that that deposition was about to happen, so they should be expecting some kind of an update coming after it. And I like to keep it high level, bullet point stuff. If something significant happened, I will obviously alert them right away. But, again, I don't want to make any rash decisions in the moment or shortly thereafter about a case simply because a witness didn't appear great or said something completely opposite. So, bull level, and then usually I'll say, hey, why don't we schedule a call for next week to discuss the substance of the testimony, or maybe after the transcript comes in, so that way the carrier and or the client, depending on if it's the client's own testimony or whatever, should be aware of the base level of the facts. But I like to let things digest and think about how it truly impacts the case before I go about freaking out or saying that's it, case closed, we won, summary judgment, here we come. So that's usually my approach for updates.
And there is a lot to cover here. I feel like doc review really makes the e-billing annoyances really small when you think of like doc review on some of these huge cases, that they are the bane of existence. I take it back. It's not e-billing, it's doc review. I think doc review in some litigation can get like totally out of control, especially if it's one that the attorneys or defense counsel is currently handling in-house and didn't necessarily realize that because of the scope of the ESI that perhaps we should have gotten an ESI vendor. So that's something at the initial, when we talked about like how many parties, the corporations, individuals, individuals, how many potential witnesses. That's also something to start looking at, is what's the volume of data we think that's going to be involved? And is this a matter in which we think it makes sense to retain an electronic discovery, an electronically stored information vendor? And there are plenty of vendors. Also, a bunch of us at the carrier may have business relationships with and negotiated rates with some of those vendors. So again, it's checking in with the handler, as well as likely sending it out for a few quotes to make sure that we're getting the most competitive like budget there. I've also found that when you do get budgets from different ESI vendors, they're like comparing apples to oranges. It's like infuriating how one will just do it based on like gigabytes and storage, but then another will do it by like reviewer and licenses. And it's hard to aggregate and figure out how much time you're going to spend, because sometimes it's monthly, sometimes it's kind of all in, and it can be really challenging to analyze those budgets. I don't want to analyze those budgets. I want my defense counsel to analyze those budgets and kind of summarize it to me and give me big picture of, we anticipate this amount of data, hosting it for this long, having this kind of reviewer done by the ESI versus us, then we'll have to do some high level. Those are the kind of budgeting things that I appreciate, giving me the ballpark total all in, because on some of these, it can get enormous. And on a lot of them, we as a carrier might have to pay those invoices manually each month. And when you have however many files, like 200 files, and it's not something where you can just go and you discovery and hit approve, 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 approve. It's something that you have to then send on to someone else with specific instructions to pay manually. It gets very administratively heavy. So on those cases, I could go on and on with my complaints. I don't know about you, Barbara. Have you had any similar pains
I feel
on
your
e-discovery?
pain, Megan. I feel your pain. Yes, all of the things you've said have also been things that I've struggled with. So I do think trying to get the budget and having it analyzed before you send it to the carrier is very important and helpful to be able to say, we've checked with different vendors. We think this one is the best. Here's why. Sometimes they may not be the cheapest one, and there's a reason why you want to use them. You've had a good experience in the past. You think that for this particular matter, they're the best fit. We're all reasonable individuals, but if you can provide us with that information in a digestible format, it's so much easier for us to be able to give you the approvals you need so we can hit the ground running. But yes, it's important just to keep in close contact with the ESI vendors. The budgets can change over time. They may find as they're searching the documents that things need to get to a much more granular level than they anticipated for whatever reason, given the way the information was stored. So just making sure that we're aware of any changes like that, so that we can prepare accordingly, reserve accordingly.
Yeah, and you as counsel may know from working with some of these vendors that they always like lowball the initial budget, and it's always a moving target, and they always go over budget. And that's helpful information for us to know of, like, here's why we're going with these, that it seems like it's more expensive, but it's because they've given a more realistic budget on this matter, as opposed to this one that is really not realistic based on our experience in working with all these companies before, because that can be really helpful. And then on matters that you keep in house with, it might not warrant e-discovery, which is sometimes great. That's excellent if it's not a large enough matter or there's not enough data. That's excellent, and you guys handle in house. But on those, I've seen some where we get like block billing, where it's like a partner reviewing documents for like 5.5 hours one day, and it just says like reviewed Bates labels like 1,000 to 2,000 or whatever. And that's something where our guidelines require that it's downstream to cheaper billers. So our e-billing reviewers will change that from partner rate to associate rate. And every once in a while I get an email from the partner saying, I did this, I want approval. And I'm like, you can do that, but you're doing it at the associate rate. If you want to review documents, I'm fine with that, but it should be at the associate rate. What your role is as partner is like reviewing the ones that the associate has flagged as hot docs or whatever, however they do it, and making sure that they're reviewing properly, but going in and reviewing for like 5 to 8 hours a day of just document review is not something that's appropriately done at the partner rate.
Yeah, I think with ESI too, like it always kind of goes back to scope too, and like what are you dealing with and what are you looking at from the front end. So for example, on these big cases where from the get-go, there's going to be millions of documents, it is what it is, then I'm going to want to know. I mean, we have it in-house one that we use, so like haven't really had to deal with too much with outside, but I would want to know, what are our capabilities with AI? What are our storage capabilities? What are the costs going to be? Because again, if it's millions of documents, I've used AI already to do it, and it's been fantastic and saved immeasurable amounts of money for clients before. So if it's going to be that case, then yeah, I definitely want that. If my bigger concern is just like storing original documents or native forms, that might be a little different. And then it's just a matter of really like, what are the storage costs? And also, there's different ways to save time. If anybody's tried a case, that, doesn't matter how complex case is, you're probably gonna have 20 most important documents out. You're not going to need all of them. So most e-discovery vendors should have the ability to archive like certain documents at some point, so that, say, after you're getting through the depositions, maybe you can archive 1 million of those documents and just keep the ones you need. And then if you need to go back to them, you can, but that can save a ton of money in storage costs. It really, really racks up quickly when it comes to storage costs. And then also kind of going back to the AI point and just general review too, is like, if you get an ESI production that is not at all what you expected, either from your own client or from opposing counsel, you need to right away ask yourself, like, okay, how many of these are your Amazon package has been delivered, or thank you for your reservation? Because if you from the get-go have thought there's no reason for it to be 1 million documents, then you need to start doing like random sampling, or start really evaluating, like, okay, was the issue with my discovery request or what? Like, this is a document dump, and there's no reason to now ask the carrier to like have me review again your 1 million your Amazon package was delivered today type emails, and figure out a way to winnow that down, whether it's by date, whether that's by like a hunt and peck method using AI, whatever it is. But if it's that outsized, and there's probably a reason for it, and there's a lot of stuff that should be filtered out outside of having an associate just go through every single document and pick out which ones are actually relevant.
It also
Yeah.
really helps with duplication. We see, especially on the large email cases where you have the same 14 attachments going back and forth 42 times between 18 different people. The third-party vendors do a really good job of culling that down, so that you've got, maybe the emails that you need and then the 14 attachments, but you're not looking at 3,500 documents. You're looking at closer to 60. So we've found that helps, especially in the day of email where everything is back and forth and back and forth. So.
And I think doc review is an area in which Gen AI will probably drastically alter how it is done, and how expensive it is, and all of it. So it's an area that I think you need to constantly be kind of checking on. If there are specific CLE on innovations or areas that is a good one to pay attention to, because that could be a really great cost benefit that you can show to your clients on how you're on the forefront kind of really making it more efficient, and not the bane of my existence, which I'd previously lumped it in with my hatred of e-billing. I think then shifting a little to what Andrew was saying about depositions and deposition summaries. I never need deposition summaries. I don't want deposition summaries. Like, I want to know if something surprising happened, something very good happened, or something very bad happened. Otherwise, like a sentence to just say, like, we deposed so-and-so, no surprises, or it went well, that's fine. What I really want is, if something surprising happened, good or bad, to tell me what that is. Like, so and so, like, if it was my insured, the client, if they sat for deposition and it went very poorly, that they either gave testimony that was not anticipated, or that they just don't present well. And sometimes those are phone calls versus emails that you might want to have. But it's sometimes something that the client also needs to know, and trying to wordsmith that in a way that doesn't necessarily break your relationship with the client and the insured, but also so that they're aware that it didn't go great, because that might not have been their perception of how they presented. So that can be a real kind of tricky situation there. And I don't know, Hannah, if you've had that come up and how you've addressed it.
Oh, unfortunately, yeah. No, and a really good point on working with your adjusters. I had a case just about a year ago, where we had spent a day doing a 30B6, and then the second day, plaintiff's counsel deposed. It was assisted living facility, deposed the manager and then the owner. And then after the depositions, I had to send an email to my adjuster saying, hey, we need to schedule a call. because the exposure level on our case between the 30B6, which went beautifully, and then the next day with the individual manager changed the complete tenor of the case. And it had nothing to do with being prepared. It had absolutely everything to do with the words that came out of that individual's mouth. But I definitely had the phone call first, set up a call, talk to my adjuster. We then the next week had a call with my adjuster and their supervisor to talk about where our exposure level had blossomed to and how we were going to start working this case towards a mediation. And so for both of those, they said, don't put it in writing yet, don't put it in writing yet. And then after we'd had those two calls, and then I think that they did an in-house roundtable, then they had me put it into a report so that they could, justify why the change in exposure, and then, taking it from a case that we were pretty confident we wanted to litigate to a case that we needed to massage into mediation. And so that was one of those moments where as you're watching your client just sink the ship and you're saying, okay, how do I get this communicated in a way that doesn't, raise alarm bells for my adjuster? And that gave my adjuster time to ask me all the questions so that she could prepare her file to go up to the next level. And that's, again, that communication and also having those relationships with the people that you work with.
Yeah, I've had two cases that really stick out. One, it actually wasn't, my client didn't end up having to testify outside of a limited hearing, but he had spoken to me before it about how someone had once told him he looked slick and that they felt that he maybe wouldn't appear good in front of a jury. He was a lawyer too, by the way, and I could see in his face like how kind of hurtful that frankly was for him. Because I mean, to hear this is just the way you look is like, what does he do to change that? And then I had another client some years back who just the way his voice sounded would just didn't sound intelligent at all. And he was a lawyer, and it was a case with a bad liability case. So all of that combined together was not a great defense case. But I think one thing that I always keep in mind is like long term, when addressing this situation, what am I looking to get out of addressing this situation, and what does the future look like? Because I can tell you right now, telling your client without knowing whether you're going to go to trial one day or not, that he's a bad witness or that he's unlikable is not going to do much for you at trial. Whether or not you want to discuss getting this into mediation, like what's necessary to get that into mediation, right? If the client's cool with mediation from the get-go, then I don't need to convince them. So I don't need to tell them you're a bad witness or you sound dumb in testimony. Like these are things that are really, really unhelpful in the event they need to testify again. And that's the same thing even with preparation. Like sometimes we've all prepped clients 1, 2, 3 days, and we've gotten to the point where like, this is the best we're going to do. He's not going to appear well. Guess what I tell him before his deposition? You're going to do fantastic. You're really good. Just keep these things in mind and you're going to do great, because you don't want to have them walking into a deposition or God forbid a trial thinking my attorney said I'm bad at providing testimony. That's not going to help your case in any situation. So just always ask yourself when you get to one of these issues, like, how frank do I have to be with my client to get to where we want to get to? Because it's rarely going to lead to a better result to tell your client he's an unlikable witness, he sounds dumb, or it's anything like that. So it's really delicate and it's really case by case, but you definitely need to pick up the phone with the carrier when these kind of situations happen.
Absolutely. That's when we want that call of this is how this is going to impact our case. The client, the insured, is going to be potentially a disaster for these reasons. Here's how this is going to impact us. If you know that going in, warning us and kind of laying the groundwork for that discussion, so that we're already mentally prepared. Okay, well, maybe this is a case that we should consider settling when, previously we were not looking at going down that path. And then, of course, reporting back afterwards. And as Megan pointed out, it should be a phone call if there's something that's sensitive that you don't necessarily want to put in writing right away. Wait for the adjuster to give you the green light to do that. Not every carrier wants something in writing that's damaging to the case, or your recommendation, with regard to how the valuation has changed in light of the new information.
And I will say, Andrew, sometimes the client though thinks it all went great and thinks that he did fantastic and may not agree to settle. Like sometimes he's like, I don't want to settle. I got this. I'm going to win it. And so in those cases, I think you do have to not necessarily say you sound stupid, but more be, you have to try to wordsmith it and like, I'm concerned on how a jury may perceive your testimony. Try to like put it on someone else. Like these juries might not get it, what you're saying. And sometimes there do have to be frank discussions because it can be challenging in those situations where you really believe as an advocate for your client that the best result is trying to resolve this prior to going to trial, but the client feels like they got this and that they can like win the trial through their stellar testimony.
Yeah, so I think that that's a tactic that is based in reality and that I use also when a client maybe thinks that they did better than they really are, is that, the way I explain it is, I've known you for the past year and a half. I think you're really likable. I think you're good, and all that stuff. But the reality is when you get in front of a jury, you have 6 hours of testimony. They're not going to get to know you. They're just going to hear a very limited part of what you did in this specific case. They will not get to know you. They will not understand like your background the way I do. And so, with that limited window, we need to look at what will happen there. And so perhaps during that window, when 4 hours of it is talking about how you maybe made some mistakes in this case, is not going to come across as likable as I know you are, because you are very likable and you're a great witness. But it won't come across. So it's a very good point too. You want to walk that line of making sure they are still confident if they need to testify, without convincing them that they're the best witness on the planet. We should never settle because we'll win a trial.
One of the joys and challenges of working in the field of professional liabilities, we are working with professionals who are very good at what they do. But one of the biggest challenges is they've been sued. And so you've kind of got to walk that balance. And that's also an area where sometimes I've had, my adjusters auto call with the client when we get to that sort of come to Jesus moment where, like, hey, everyone needs to come to the table. We're going to look at all of our warts and wrinkles, and we're going to work together to get the best resolution possible. So especially when you have some of those more difficult clients, you sometimes need to work with your claims handler to say, okay, like we've got to have a battle plan here. So real quick, because we've got about 12 minutes left, talking about the middle of the case, motions. We've got discovery motions and MSJs. And I think gone are the days where every single case was going to be a MSJ ready case, right? So Megan and Barbara, if you can kind of chime in on your thoughts on working with your team on when motions are appropriate, when we want to file them, when we don't want to file them. What do you need from the claims side?
Well, I'll jump in, I guess. I can tell you that I work with some carriers that think motions are never successful and they're never worth the money. So you're kind of already starting off on the back foot, convincing us that a motion is necessary here for any given reason. That's not the view of every carrier, of course. And, us individual adjusters may not agree with the corporate mentality. I personally think that there are times when summary judgment is absolutely appropriate if we are well prepared going in and we really know the lay of the land and we have a favorable assessment of the success of that motion, it's worthwhile. And I do also agree, I know Megan mentioned this earlier, that sometimes you want to file summary judgment to have a bit of leverage at a mediation. That can be very helpful if, it's executed correctly and at the right time going into a mediation, to have that bit of skin in the game, so to speak, for the plaintiff, especially if you're dealing with already having tried early attempts at settlement, early settlement talks that have been unsuccessful.
Yeah, I agree with that. I think that summary judgments can be useful tools. I think that sometimes, especially if it's something that you're planning to file a summary judgment and then try to mediate it, that it can give the mediator an argument to say to the plaintiff, look, you might get a goose egg here. There's a chance that you're going to get nothing. And it can also help with plaintiff's counsel who may be lazy plaintiff's counsel that, hey, you're going to have to respond to this summary judgment motion. And it's going to be a lot of briefing if timed properly, sometimes that can be helpful to resolve things and to give motivation on different parties or different, the plaintiff and the plaintiff's counsel on trying to get it done, whereas maybe they were on the fence without that motion. I think that I feel very differently about discovery motion practice. I don't think I'm quite as gung-ho about discovery motion practice as I am for motions for summary judgment. I think motions for summary judgments are almost always a useful tool, whereas discovery motion practice, it's like, do we need this? Why are we filing this? So most judges, it seems, increasingly hate discovery motion practice. Often they have different special masters who deal with it, or magistrates who deal with it, or they just get annoyed on the phone or have phone hearings and are just annoyed. They're like, why are you bringing this to me? I don't know any judge who really revels in discovery motion practice. So I think if we can avoid it, great. If we can't, if you're like, I have to file this motion for summary or this discovery motion to compel because they haven't given our responses, and if they don't and it's granted, then we can potentially file for a motion for summary judgment based on for sanctions. I think that courts seem to be becoming increasingly frustrated with discovery motion practice, and we're seeing more and more just real sanctions on what we used to be the draconian measure of terminating sanctions, striking an answer, striking affirmative defenses, striking a complaint. And we're seeing judges employ those now when they get really annoyed with parties with their discovery back and forth, or their discovery refusals to produce documents, or not enough documents, or hiding documents. And we see that on the legal now side, because then those become claims against the lawyer who's litigating. So you don't want to be in that situation in which your client's not giving you the documentation, or that you're trying to kind of play some games and try to keep things and not give them everything from that you think this might be a strategic advantage by only giving them these documents. And then we get really hammered by a judge because we are seeing increasing just volatility in judges there.
We do a fair amount of bar bench pleas, and they routinely tell us how much they hate discovery disputes. One thing that we have seen change really since COVID especially is before you can file a discovery motion in pretty much every one of my jurisdictions, you have to have an informal discovery conference with the judge. And those have actually been very effective because they will craft an idea for you to consider, which is really telling you, yes, you're going to do this or you're going to get, in trouble. So those have helped a lot. But yeah, I mean, I don't know a single conference, bar bench plea that I've been to where a judge has not brought up how much they hate discovery, motions and not to file them.
Yeah, I'm very selective about discovery motions. Like Megan said, the question I always ask myself is, how bad do I need this? Do I really want to quibble over a couple of interrogatory responses when I'm going to depose the witness anyway? Do I need the email from 30 years ago that has nothing to do with anything? Probably. These are the questions I ask. And then also, is this necessary now? If this is a case that we targeted for early mediation from the get-go, then okay, if that mediation is going to happen 6 months before the discovery deadline, why don't I just put this in my pocket? And if God forbid it goes to trial, I'll be able to file the motion, get whatever documents I need, and deal with it then. But I don't like to jump to discovery motions because, like everybody's been saying, courts hate them. It can't be a quibbling over stuff. It better be I've sent 5 requests to give me deposition dates and I've gotten 0 responses. Okay, then I'm ready to file that motion. But when it's in a gray area, I really, look at it closely and consider what's the actual value and how likely is it the judge is just going to get annoyed with me.
Well, and I guess also know your rules of civil procedure, because oftentimes there are steps you have to follow before you can file that. And if you don't have that meet and confer letter and you don't have that certification, we've had judges, and that's just a practice point that unfortunately you get to learn by experience. But yeah, if you don't have those in the file and with your motion, it will get summarily kicked.
Yeah, and it's good to know too. That's where it's helpful for you all as practitioners in these jurisdictions to know your judges, know your local rules, know what their preferences are. So like Hannah said, where they always have these kind of bench conferences and all of these, like that you know that and that you can kind of foresee that and know how it's going to go and not just be like, I'm going to draft this motion now and spend a lot of time on this motion, because you kind of know that that's not usually how it goes. You usually have these meet and confers and then with the judge beforehand. So that can be really helpful.
We got about 4 more minutes left. Claim handler, pet peeves on discovery and litigation. Let's hear it.
Where to begin?
I feel like we've already talked about many
Right.
of them.
Yeah, that's kind of like the impetus behind this whole thing. It's litigation soft skills. It's like avoiding our pet peeves, essentially, is what this whole series is. But I think just from the get-go, that whenever speaking to any counsel on any sort of format, I have to remind everyone to put the claim number in the subject line of the email, please. I think a discovery that could be very helpful too, because if in the middle of the case, because we need to then, sometimes we're just throwing stuff into the file, that's like really all this is. It's not necessarily anything I need to respond to. But communication is key on these. It's been like the thread throughout, is to kind of know what your guidelines are, know what your claims handler's preferences are. You know, like I mentioned, I don't want deposition summaries ever. I think most carriers or most claims handlers are like that, but maybe they're not. Maybe someone expects it. So know that. I don't need every piece of discovery or discovery request that you're serving. I don't want to be on the back and forth of scheduling depositions. Maybe some do, I don't, but those are things that you need to know. In the subject line of the email also, I want to kind of know what is going on in the email. So if it's something where it's like, surprise at deposition, like put that in the subject line, not like please see attached, right? That then has a PDF that then halfway down this letter says that the insured gave terrible testimony and now our claim or our case is dead in the water. Like that should be highlighted somewhere in the subject line or like first sentence. So that's kind of another big pet peeve in this area, because I think there is the tendency sometimes to kind of overlook the middle of the case. It's kind of like things are locked and loaded and set. We had our initial preliminary discussion where we have our resolution plan based on our preliminary analysis. Now we're just going, but this is really the area in which you need to let us know when there are changes, when there are any bumps in the road, when things happen, because and bring our attention to it so that we don't miss it.
Absolutely. Highlight what is changed, highlight how that impacts our case, flag any important dates and deadlines very clearly, and don't bury them in an attachment, please. As Megan pointed out, a lot of the claim professionals are handling in excess of 200 claims. It's really hard to keep track of all those dates. So if it's a summary judgment deadline, if it's identifying experts, all of that needs to be upfront as soon as you know it, so that we can be part of the discussion of whether we are going to go down this path or not.
All right, 12:29. And let's see, I guess as a wrap up, Andrew, you're going to be doing and posting top 10 tips, is that right?
Yes, that will be posted on LinkedIn in the near future.
Yeah, Andrew's going to do a top 10 takeaway from this presentation. Thank you guys so much for joining, and for Hannah, Barbara, and Andrew agreeing to participate in this webinar series. Stay tuned, everyone, for the final installment coming on the end of the case. Who knows what that will be? Dun, dun, dun. It's like a cliffhanger. And remember to sign up for the annual meeting. And thanks so much. And Sandra, are there any final housekeeping items that you would like to mention? Nope. All right. Well, thanks, everyone. Hope you all have a great day. Take care.
Thank you.
Thank you.
Bye.